Good morning. Welcome to the House Judiciary Committee. This is the 16th of January, 2025, and we're going to have a briefing related to felony murder. We're going to hear first from a panel from the Office of the Public Defender, and if you want to come on up, we'll bring you up, but we also have virtually Mona Sahaf from the Vera Institute who's going to be joining us. She's going to be making a presentation as well. Committee, my goal is to not go any later than 12:30 today. So I'm going to try and apportion the time fairly and equally. So hoping that the presentations from both OPD, Vera, will be about 20 minutes, give or take. I think it's a little more time than we thought we were going to be able to give them. And then from the state's attorneys, about 20 minutes at the beginning, which leaves times for questions after each side. And so with that, she's not there. Do you feel comfortable starting? And then we'll come to the person from Vera after that, or we can wait a little bit longer to try. Which do you prefer? We could go ahead and start right now if you'd like. We are prepared to start. Okay, that's great. That's fine. We'll go ahead. And thank you very much. Go ahead. Mr. Dartigue, please.
Thank you. Good morning, Chair Clippinger, members of House Judiciary. I am Natasha Dartigue, Maryland Public Defender. Seated to my left is Leela Meadows. She is part of our OPD decarceration initiative, my resident subject matter expert on the issues related to felony murder. Thank you for allowing us the opportunity to provide you with the facts and the research and the information today in regards to felony murder. Next slide, please. On our agenda today is first that we will define felony murder. We will speak to you about the failed logic of the law, as well as its application. We will speak to in that felony murder as it stands now is a strict liability crime. We will speak about how prosecutions look in Maryland and the financial tolls. And then we'll also propose reforms to move Maryland forward. Next slide, please. So felony murder as it's currently defined is a legal doctrine that allows someone to be charged with and convicted of first-degree murder if they participated in certain felonies in the course of which someone is killed, even if they did not intend to kill, did not actually kill, or did not know anyone was killed. And historically, a life sentence is mandatory for anyone who is convicted of felony murder. I give you an example. We have a situation where there are 4 hungry teenagers. Not one of them have any money, but they come up with the idea that they're going to order some pizzas, and when the delivery man arrives, they're going to forcibly grab the pizzas away. And so that is the plan. The delivery man arrives, and in fact, they forcibly grab the pizzas from the delivery man, but there is a struggle. One of the teenagers strikes the delivery man, and as a result of his injury, he dies. All of the 4 teenagers are charged with felony murders, including the 3 who did not intend to kill, did not actually strike the delivery man, and did not know that, in fact, that he was going to be struck, as that was not part of the plan, nor was that their intention. Under the current criminal law code, the felonies that apply to felony murder are listed in front of you. So, for example, you'll see it's arson in the first degree. It includes carjacking. It includes kidnapping, mayhem, and rape are examples of the felonies that are applicable under felony murder. Next slide, please. The elements of felony murder that the state must prove beyond a reasonable doubt are these. 1, that the accused committed or attempted one of the enumerated felonies. 2, that someone was killed during the commission of that felony. And 3, that death resulted from the accused participation in the underlying felony. What you should note that is extremely important, that is not missing, is that there is no requirement for the state to prove an intent to kill, although their burden is beyond a reasonable doubt. Other examples of application when under the felony murder rule, where an individual convicted of first-degree murder and receives a life sentence that we've seen is, again, you have 2 teenagers who plan a robbery of a convenience store. During the robbery, one teenager pulls out a gun and shoots the clerk. Both teenagers are charged with murder, even though one of the teenagers has no knowledge that the other has a gun or intended to shoot or kill anyone. A second example, you have a group of persons that are involved in a robbery of another convenience store. But in this scenario, there's a driver who stays in the car. So one person is the getaway driver. The driver remains in the car and has no idea what is taking place inside, or that the situation inside has escalated, or that someone has been killed on the inside. So there we have, there is no knowledge, and that person is not present, but yet the felony murder rule applies. In both scenarios, there's no intent to kill, yet both would be convicted and receive a life sentence.
What the public defender has laid out in terms of the state's burden and the fact that people can be convicted of murder without even any knowledge, without even being present at the underlying crime, is really out of step with what we do in Maryland law. Mens rea intent is important to us when we charge conduct. And so the logic behind the felony murder rule is really one of foreseeability. And we say, you know, if you're going to be involved with a particular crime, you should be able to foresee that something like a murder could take place. And so we tolerate this in the law as of right now. And the logic of that is that this is a way for us to deter crime, because people should be able to foresee that this should happen, and therefore, if they know that they could be convicted of murder, they won't engage in these underlying crimes. The problem with that logic is that we know, anecdotally as public defenders, but also through the data that is emerging as we study this issue, that deterrence doesn't work. And there's 2 reasons for that. The first is that people don't often know about the felony murder rule, and I'm going to talk about a study in a couple slides. And if you don't have knowledge that this can happen, there can't be a deterrent effect. And the second, it has to do, I think, with some of the situations that the public defender has already articulated where this tends to play out. And I'll talk more about that. Next slide, please. And so, you know, I've been coming to the committee for a number of years advocating for felony murder reform, and one of the things we hear is that we have to have the felony murder rule in order to hold people accountable under the law. And that's really just false. There are a number of things that individuals can be charged with when they are involved with a crime that does lead to a murder in the commission of a felony. And so prosecutors are still able to charge individuals with premeditated first-degree murder, where the facts lend itself to that. And that, of course, carries a mandatory life sentence. Second-degree murder, which carries 40. Conspiracy to commit murder, which carries a life sentence. And then, of course, there's the underlying felony. And in the examples we gave, robbery is a really common one that we see. And robbery itself carries up to 20 years. If weapons were involved, those sentences can stacked consecutively. And so it's just not the case that if we didn't have the felony murder rule, we wouldn't be able to prosecute and punish the underlying conduct. The law is in place to do so. And so what we really have is a law that's operating as strict liability. We're punishing individuals not just for their own conduct, but for the conduct of others. And that's really out of step with what we do in Maryland and sort of the tenets of criminal law. We're relieving prosecutors of their burden to prove intent, or as lawyers say, mens rea. And again, this really isn't supported by the idea that it's a deterrent, and so, you know, it's justifiable. There's a study that just came out of Minnesota, which is one of the states that has looked at reforming the felony murder rule, and I think that you're going to hear maybe more about what Minnesota has done from our colleagues at the Vera Institution. But it was really remarkable in what it found, and one of the statistics that really jumped out at me is that less than 1% of individuals at the time of arrest knew about the felony murder rule when they were arrested and charged with that. Next slide, please. And so again, I know that this committee has had various pieces of legislation before it, some of which have dealt with felony murder in juveniles and youth. And the strict liability here creates truly a special injustice for children, because this is a doctrine premised on the idea of foreseeability. And we know that children are less able to foresee consequences and risk the way that adults are. And we know that, and the Supreme Court has acknowledged it in cases like Roper, Graham, Miller, all of which have to do with extreme sentencing of children. But also this body recognized it when it passed the Juvenile Restoration Act. Part of the legislative intent behind that was recognizing that youth really are different, and we have to treat them differently when it comes to punishment. And yet here we are still in the business of charging youth with felony murder based on this foreseeability doctrine and the assumption of risk. And again, I would just reiterate, it just isn't the case that we can't charge youth with their actual underlying conduct if we don't have the felony murder rule. All of those tools are still available for prosecutors in cases where it's appropriate. Next slide. So when I've been before the committee in the past, one of the first questions I often receive from members is, what is the scope of this problem in Maryland? When we talk about the number of people being convicted of felony murder, the number of people who are still incarcerated for felony murder, serving life sentences, what does the number look like? And I've never been able to answer that question for you. And part of the entire reason for that is the way that the statute is constructed. Again, felony murder is charged as first-degree murder, identically as premeditated murder. And so there's no way to go to the Administrative Office of the Courts or even our colleagues in the Department of Public Safety and Correctional Services and say, run a query and spit out all of the cases where someone has been convicted and is serving a sentence for felony murder. It's just not possible because of the way it's charged. And so we're trying to answer that question with a limited data set. The Administrative Office of the Courts has provided every case where first-degree murder was charged from 2017 to 2019. And I've taken a look at those cases with the help of a colleague, and I've started to pull documents from the case, from the statement of charges to jury instructions where there was a trial, transcripts in cases where there was a plea, to look at the agreed-upon statement of facts to try to determine what theory the state prosecuted the case under, to get to a number that we could then extrapolate from. There are a large number of cases within that data set, and we're talking about 466 cases just in those 3 years, that at this point, I don't have enough information to be able to reliably classify as either premeditated or felony murder. We just can't make a determination, either because information is missing or because the information I have just isn't clear. But based on the cases that I could classify, about 10% of the cases appear to have been prosecuted under a felony murder rule. Now, again, there's a huge caveat, huge asterisk that I want everyone to put next to that number, because I'm continuing to work on this pool of cases that I can't make determinations in yet. And I do expect, consistent with what we see in other states, that that number will rise when I'm able to make determinations in the additional cases. But for now, we're sitting at about 10%. So outside of the very real human cost when we pass these really excessive sentences, this is taking a financial toll on the state as well. The latest number I found from the Division of Corrections is that we're sitting around $60,000 a year to incarcerate an individual, and that the average sentence length in Maryland is now over 19 years. And there have been national studies from organizations like the Sentencing Project that show that felony murder is a contributor to this explosion in over-incarceration that we see nationally, but also in Maryland. And I know that our colleagues at VERA may talk about in California that's undertaken some reform, what some of the savings have looked like, which is, I think, an important consideration for this body. And so, the public defender is going to talk a little bit about what needs to happen to correct this injustice. But what I want to say before that is that Marylanders are with you should you take that step. The Maryland Alliance for Justice Reform recently commissioned a survey of over 500 Maryland residents. And this was conducted by Professor Ian Farrell from the University of Colorado Denver Strum College of Law. It's a mouthful. I hope I've gotten that. But what the survey found, among other things, is that 92% of Marylanders believe that non-principals should not be convicted of first-degree murder, that is out of step with what we should be doing in the criminal legal system. And only 6.6% of respondents were aware that when you are convicted of a first-degree felony murder, it carries a life sentence. People did not know that, which again, I think, gets at the fact that this really isn't an effective deterrent. And when asked what they believe the appropriate sentence was for non-principals, the median opinion there ranged between 5 to 10 years. And so again, this isn't my research, but it is research from a law professor at the University of Denver that I believe is being released. The Maryland Alliance for Justice Reform has a press release that's going out, I believe, today, and this will be available to everyone at the committee and will be available on OPD's resource page as well. Next slide.
So just as a heads up, I was going to give you and the person from VERA 20 minutes. We're at 20 minutes now. So if you would begin to wrap up, please.
This is, in fact, my last slide and my charge to each of you. In terms of moving Maryland forward, we are asking that you enact reform that centers justice and fairness by requiring the state to meet its burden of proving a case beyond a reasonable doubt. And that means proving an intent to kill in all first-degree murder cases. This would also include retroactive relief for those who have already been serving a disproportionate sentence for the felony murder offense. Next slide, please. We do provide additional resources. You will have copies of our presentation. Within the presentation are hyperlinks that will take you to the various studies in addition to other resources on the subject.
All right, thank you very much. Mona Shahaf, please.
Good morning. Mona Sahaf here from the VERA Institute of Justice. Thanks for the opportunity to speak to the committee about this important issue. I'm about to pass the mic over to Adore Onyekwere from the VERA Institute of Justice. We were asked to provide context about a little bit about the origins of the doctrine, the felony murder doctrine, and what's happening around the country nationally in terms of attempts to measure the impacts of felony murder doctrine and reform the doctrine. So I'll pass the mic now to Adore. She's on screen. Thank you.
Good morning, everyone. Just waiting for my slides to pop up so that we can begin. But just first, thank you for having us here. My name is Adura Nyekwe. I'm a senior program associate at the Vera Institute of Justice in the Reshaping Prosecution Initiative. As my director and boss said, today we're going to be diving into, as we've probably heard from OPD, into a highly kind of controversial legal doctrine, which is felony murder. And for our presentation, we're going to touch on the doctrine's origins, critiques, and the national reform landscape, and some other things in between. So, not sure, did you want me to share my screen or?
Do we have the PowerPoint here, or we have it here?
Yes.
Okay, she's loading it in. Just give us a moment.
Of course, not a problem. And thank you all for your patience. All right, we can kind of skip the next. Yeah, we can skip into this. Oh, the next slide. There we go. All right, so I know OPD's already kind of talked to you about what felony murder is. They've probably done like a deeper dive, but just like a kind of an overview and to lay the foundation of what we're going to be talking about. I'll just give a brief overview of what felony is, just in summary. Like, essentially, the felony murder rule holds a person liable for murder because they kind of set the chain of events that led to the death in some kind of way. I've even heard the felony murder rule called the but-for rule in conversation because of this. We can move to the next slide. I think you skipped, oh, there we go. Yeah, I think you skipped the slide. Okay, I think there might be an error on our end, but essentially, just to kind of let you guys know, so only 2 states across the country, like out of the entire country, have absolutely no felony rule statute, which are Kentucky and Hawaii. All the other states, federal government, and DC currently have some version of the rule on their books. And what we're looking at on these slides are, we're looking at 2 competing theories on the interpretations of the felony murder rule, which are the agency theory and the proximate cause theory. And with agency theory, a person is only held liable for deaths caused by themselves or their accomplices or partners in felony. And with the proximate cause theory, a person's held liable for any death occurring in relation to the felony, regardless of who did the actual killing, such as a partner in the felony commission, police officer, or some other third party. You can move into the next slide. Oh, it looks like they switched up, but yeah, you can skip this one. There we go. In most circles, felony murder has been thought to have been first conceived from English common law, specifically William Hawkins in his 1716 Treatise of the Pleas and Crown, which, as a side note for everyone in the room, also has a chapter that's called of witchcraft, because at the time witchcraft was considered part of the criminal offenses, and I just thought that was kind of hilarious and really, really interesting. But the treatise itself has been considered as the more so modern conception of the felony murder rule. You can move to the next slide. But modern research, or more recent scholarship, proposes that felony murder, as we know it, in the kind of strict liability sense, was never part of English common law and was rather just a debated concept and legal theory. And the first actual recorded theory, from which you can see on screen here, was a murder statute in Illinois in 1827, where malice, where they defined that malice could be implied by circumstance. And you can move to the next slide. And I'm sorry if I'm moving fairly quickly. This is just like a quick 10-minute presentation, and I wanted to kind of leave room for questions. So if you have any questions, feel free to ask them at the end. So felony murder regardless of if it was from English common law or whether it originated within the states, is a doctrine that's really deeply embedded in our country, leaving it an outlier internationally. As you can see, out of all the common law countries, only Australia and the United States still have felony murder on their books and utilize that rule. You can move to the next slide. Okay, so we're going to touch on some of the main critiques of the felony murder rule. I'm going to just kind of run through them on this slide, and then we'll dive a little bit more deeply into them. So first, one of the first criticisms is that it yields severe racial disparities and exacerbates inequities. The second one is that it promotes coercive plea bargaining. The third one is that it leads to excessive and disproportionate sentences. And the fourth one is that the rule itself is just fiscally unsound with no meaningful public safety impact. And just so you know, these criticisms, they are not exhaustive. These are just some of the ones that we decided to highlight for today. You can move to the next slide. So, the felony murder rule yields severe racial disparities and exacerbates inequities. So, the most impacted people by the felony murder rule are women and survivors of sex trafficking, DV, and intimate partner violence. We have youth, young people, and we have Black people and people of color. A survey in California, for example, found that 72% of women, but only 55% of men serving a life sentence for felony murder were not the principals of the killing, meaning they did not kill anyone. And in addition to that, an incarcerated women's coalition reported that most of their members convicted of felony murder were accomplices that were grappling with intimate partner violence at the time of the offense and were in fact criminalized for acts of survival. And in terms of, oh, no, you can go back. You can go back to that slide. Extensive research across various disciplines, like in terms to how youth are impacted in a disparate way by felony murder statutes, are that, just as we know, various disciplines, including neuroscience, psychology, and criminology, indicate that unique cognitive and emotional vulnerabilities of youth make them just particularly susceptible to being charged with felony murder, because felony murder laws, they just operate under a flawed assumption that all individuals, regardless of age, can really fully comprehend and anticipate the potential consequences of their actions and the actions of those within their social groups. And in terms of racial disparities, felony murder rule yields very, very severe racial disparities and exacerbates a lot of different inequities, such that I'm going to use New York as an example here. Black people within New York are 20 times more likely than white people to be arrested for and convicted of felony murder. You can move to the next slide. And felony murder also exacerbates or promotes coercive plea bargaining. As you can see on screen, this is from a New York study of felony murder that went from 2008 to about 2021. Essentially, like the felony murder rule grants prosecutors significant plea bargaining leverage. They can compel defendants with severe, potentially excessive punishments under felony murder, coercing them to plead guilty to lesser charges. And these reduced charges often still carry harsher penalties than the inciting felony warranted. As you can see on screen, in the New York study, there were, out of 928 felony murder arrests, 88% of those were convicted and sentenced for some offense. 67% of those convictions resulted in a plea. 81% of those pleas were for an offense less than murder. One of the lesser included convictions was for, I believe, like a fourth-degree weapons possession, which certainly is not equivalent at all to the original arrest of felony murder. You can move to the next slide. So this is a great map that I borrowed from the Sentencing Project that kind of shows the breadth of what sentences for felony murder look like across the nation, all of which include or don't include life without parole as a mandatory, like it's mandatory that this person will get life without parole, all the way up to states that just like Hawaii and Kentucky that don't have felony murder on the book, and those that do not have life without parole as an option. Felony murder just really widens the net of excessive and disproportionate sentencing. As an example, pulling in both Pennsylvania and murder, just to give you an example, 25% in both Pennsylvania and Michigan, 25% of people serving life without parole sentences were convicted of felony murder. And that's a huge chunk of people in both of these states. 25% of them, of people serving life without parole, are just convicted of felony murder. You can move to the next slide. Okay, and this is kind of what OPD was alluded to.
Possible for you to speak just a little bit louder? Your microphone is very muffled. And we've been doing the best that we can. Thank you.
Oh, I'm so sorry about, can you hear me better now?
That's much better.
I'm so sorry. Okay, I'm projecting in my room, in the room I'm in. I apologize. Okay, so from what I've seen just across, just reading a bunch of various articles, whether it be newspaper articles or law review articles, you just find that felony murder laws spend taxpayer dollars on incarcerating people, a lot of the times for life, as we saw in the previous map, who just don't pose a danger to the community, and they divert a lot of resources from effective investments that do promote public safety. As an example, California, which reformed their felony murder rule back in, I believe, in 2021, just as a result of reforming their felony murder laws, they saved taxpayers between $94 million and $1.2 billion just from reform. So we're not even talking getting rid of the rule or anything, but that's just from sound reform. You can move to the next slide, and please let me know if you can't hear me. I do apologize for not being as projective earlier. So as previously mentioned, the felony murder rule is a highly controversial legal doctrine, and consequently, the idea of reforming or abolishing it is really not a new one. About 20% of the country has reformed their felony murder laws. You can move to the next slide. To start with, in terms of who has abolished it, as I told you earlier, Kentucky is one of those states. Kentucky abolished their felony murder over half a century ago, along with all of their common law statutes. And when creating its penal code, which is something I thought was particularly interesting, they divided their criminal homicide specifically and intentionally into 4 crimes: murder, first-degree manslaughter, second-degree manslaughter, and reckless homicide. And the statute that defines murder requires an intent to kill. You can move to the next slide. One of the more recent reforms was actually in Minnesota, and we're using Minnesota kind of as an example of what it looks like when states just kind of narrow their scope. In 2021, Minnesota reformed their aiding and abetting statute by redefining the role of what they considered a major participant, meaning a person can only be convicted of aiding and abetting if they use the deadly weapon, if they cause substantial bodily harm, if they actually hired the killer or someone closely involved in the homicide, or if they impeded another person from preventing the death. Essentially, the person would have to actively be doing something to contribute directly to the harm or death of someone outside of just participating in an underlying felony. And you can move to the next slide. Thank you. So the Pennsylvania Supreme Court, and I pulled them in as an example of who is considering reform, because like I said, it's not a new or novel idea for states to be considering reforming their felony murder statutes. Most recently, in October of last year, the Supreme Court is considering a case that challenges the constitutionality of mandatory life imprisonment for individuals convicted of felony murder. And the appeal is essentially considering whether the harsh penalty of life imprisonment violates the state's constitution's ban on cruel punishments. And the reason I thought they were interesting, because another state that is considering reform of felony murder is also New York. I thought it was just really interesting because of the particular opinion of one of the justices of in this appeal, Justice Donahue, who in her oral arguments noted that individuals are being punished for a crime without any established level of criminal intent. And she really emphasized that it raised serious questions about whether such a sentence really constituted cruel and unusual punishment, which, you know, in my opinion, and like this is just my opinion, that the court seems kind of receptive to the argument that felony murder violates the state's constitution's ban on cruel and unusual punishment. We can move to the next slide. Thank you. So over the years, so what we have here are kind of my gathering of all the various different types of reform that have been done in various states across the country, all the way from elimination of felony murder, all the way to kind of more just limiting the predicate felonies of felony murder. So over the years, various states have really reformed felony murder laws to eliminate them entirely. Some states have just de facto eliminated felony murder, because judges have recognized the lack of necessary mens rea. Some limit the scope of felony murder's application. Some reduce the sentences or the punishments, and some just change the conditions under which someone can be convicted. So I just want to reiterate that the move to reform felony murder statutes has really going on for quite a long time now. And, you know, if we use Kentucky as like our standard, so it's about 50 years. So, you know, essentially Maryland is in really, really, really good company. And I hope I have reached my 10-minute mark. I think that's my time. I hope I haven't gone over, I mean. So I thank you guys so much for your attention. Thank you for your grace on the fact that my mic clearly wasn't working in the first half of this presentation, and open to any questions.
Fortunately, we have closed captioning that was able to pick it up, so that was
great. Oh my God, I have my first
very
transcript.
helpful. So it ends up working out. All right,
Thank you so
Delegate
much.
Kaufman for a question.
Yes, I first of all, Mr. Chair, I want to commend you for closed captioning this session. It'll make our meetings much more inclusive. So, but my question is, my question is for Ms. Meadows. You in your slide sort of gave state's attorneys an alternative path to charge individuals. But could you please articulate as to why you feel those charges are more just as compared to felony murder? And it's always nice to see you.
Thank you so much, Delegate Kaufman. So what we're getting at here is that the law's meant to charge conduct that someone actually engages in, not conduct that someone did not intend and did not actually engage in. And so if the state can prove beyond a reasonable doubt that someone is a participant in a robbery, they can charge that robbery. What we are asking for is an end to essentially a legal fiction that allows the state to charge someone with a murder that they did not intend to commit and did not actually commit.
Thank you, Mr. Chairman. Thank you, panel, for coming in to testify. On the 1% that know about this rule, are they adults, juveniles, or can you say what the mix is?
In the Minnesota study, I believe that encaptured anyone who is arrested and then charged with felony murder.
That doesn't help me because I can't tell whether it's adults or juveniles. But let me say this: if it's adult, why don't they know about this? When are you gonna? Who teaches? Whose responsibility is it to teach the general public what is acceptable in society? No answer. Okay. Thank you very much on your opinion to the lady that testified. So I would like to say this on education. While you think it's hilarious, witchcraft at that time was considered as part of normal life, like what has become alchemy, chemistry, herbology, physics, quantum calculations, metaphysics, and so on. So I thank you very much for your testimony.
Thank you, Mr. Chair, and thank you both for being here today. My question is with regards to the very first part of your presentation with regards to the life sentencing. Is this, if a conviction of felony murder, is this a mandatory life sentence or is there judicial discretion? And my second part of the question is, can it be a life with parole or without with regards to sentencing? Just to clarify the life sentencing portion of your presentation.
So felony murder isn't delineated in our sentencing from premeditated murder. And so the way the statute reads is the sentence for first-degree murder, whether it's premeditated or felony, is life. Judges retain discretion under a case called Wooten to suspend a portion of that sentence when it comes to adults. And the Juvenile Restoration Act that this body passed in 2021 actually allows sentencing courts to sentence youth to sentences that are less than the mandatory, which is why the slide says historically. So for adults, again, it's a mandatory life sentence with discretion to suspend a portion. For youth, judges can sentence below the mandatory now.
So could it be with or without parole?
Yes, it can also be life without parole. I'm representing 2 clients right now serving life without parole for felony murder in which they're the non-principal.
Thank you. Thank you.
Vice Chair.
Thank you, Mr. Chair, and thank you, Madam Public Defender and Ms. Meadows, for being here today. I want to drill down a little bit on attempt because the law says that that attempt can be included. My understanding of attempt in the state of Maryland would include substantial steps towards some act and not mere preparation, but not completion. So I want to drill down on attempt and how states use, or how individuals are prosecuted based on an attempt under felony murder. So for instance, if you decided you wanted to, you were going to rob a store or whatever, and let's say you did everything, you were on your way, and you just didn't make it. You just didn't do it. Something happened that maybe stopped you from it, but you were going to do it. If there were if while you were there, or after you got there, okay, let me give you a better, let's not give you a hypothetical, okay? My point is this: how do states' attorneys use attempt as a portion of felony murder? Can you give me an example? Because obviously I can't come up with one. Because the law says when a homicide occurs in the perpetration or attempt to commit these crimes.
I'm sorry, Madam Vice Chair, I'm not clear as to your question.
My question is, and in the law, it says that one may be charged with felony murder if they attempt to commit any of the felonies that are listed there.
Yes.
Attempt, a mere attempt. I would like to discuss how that falls into felony murder, because obviously we know that intent is not required with respect to felony murder. So I would like to understand how attempt is used, if we have an example. And if not, then I'll go to my next question.
Okay. Just for clarity, so what I'm hearing is the intent in terms of the underlying felony is what we have. And you're asking for examples where the state perhaps seeks felony murder in a scenario where that one individual who is charged with attempt but is not part of the felony itself, correct? Do we have any?
An example doesn't come to mind.
I'm sorry?
I can't, an example
Okay.
does not come to mind.
That's fine. I personally, the reason why I was asking is because I don't understand it. I don't understand. I learned felony murder in law school. I don't understand how we can hold someone for life for the mere attempt of a felony that they did not complete, and someone died. So I wanted you all to help me to understand that, but I see you don't understand it either.
Correct.
Okay, thanks. I'll ask the state's attorneys as well, because it doesn't quite make any sense. The other thing was the woman, Miss Adore, I can't pronounce your last name because I can't see it, but you touched slightly on the constitutionality. I've never believed the felony murder to be constitutional. I would like to you just to go a little bit further to the cruel and unusual punishment piece that you went to with respect to the constitutionality. Could you just drill down that just really briefly on whether or not there have been any, what the challenges were and whether or not, how far did that argument go?
So, of course, thank you so much. And it's Adure and Yakure. I'm so sorry if you can't see my full name. In terms of where it's gone, I'm still currently waiting to hear what the results of it are. I have not seen any movement on it so far. Like I said, the arguments were heard, I believe, maybe October 8th of just like this past year. So I have not heard any results of it yet, but just to answer your question.
Okay, thank you. And Mr. Chair, if I could just ask one more quick question. What I was getting at with the attempt is the portion that Ms. Adore mentioned with respect to, I believe it was Minnesota, and Ms. Meadows, I think you mentioned Minnesota as well, and that requires you to be at least a major participant. So that's where I was going with that. I was just trying to understand the attempt, which is merely the substantial steps, and you're not even a major participant. You're just someone who didn't even maybe complete the arson or complete the burning or whatever, the kidnapping, or any of these other ones. So that's what I was trying to get to, but I'll ask the state's attorneys on that question as well. Isn't that so?
Okay. Delegate Phillips, Delegate Boucher.
Good afternoon. Thank you, Mr. Chair. Good afternoon, and thank you to the OPD and the staff and Vera Institute. This question may be more for the Vera Institute in your studies. The application and the charging, our OPD talked about there are other options for charging. And I'm trying to figure out if there's any research as to the disparity of the use of other charges. So let me talk this through. State's attorney in a very hard on crime jurisdiction, when the opportunity presents itself, instead of charging the lesser, charges felony murder on a regular. The state's attorney in a different jurisdiction charges the intended crime, i.e. burglary. Do we have any research on that latitude and the ambiguity of charging? And is that, because it seems to me when you do have the option to charge something lesser, but you use felony murder, that could be, there could be some disparate treatment in that. And the OPD, Office of OPD could respond to that as well.
I don't know if Vera is planning to respond. What I will say is that group of cases I mentioned that I'm analyzing from 2017 to 2019, one of the things we're looking at, look, I can't pull the entire universe of charges out there, right? That it's just not doable. But for those 466 cases, one of the things that I do plan to look at is how the case resolved and whether or not cases are pleading down to lesser includeds, which would tell us that felony murder is being used as a plea bargain cudgel, which I think Vera did present on. And that is one of the things that we'll look at. But your point, I think, is very well taken. It's just really hard for us to get at that data.
I'll just say from pardon me. Just to be quick, Vera doesn't have data on that, but I can tell you we have studied prosecutorial decision making across states. To your point, there is wide disparity in general in charging decisions from county to county within states, across states. There's just not measurement that we have that's specific to felony murder, but the way prosecutors use their discretion does vary widely based on where you live in the country and sometimes even where you live within a state.
All right, now I'm going to Delegate Boucher, please.
Thank you, Chairman. I appreciate the OPD showing up today. You have a thankless job, and you're a vital part of our civilization and our public safety. What we've seen here described today is the unintentional killing of someone while committing a dangerous crime. If you look up third-degree murder, that is its description, and you are not allowed to sentence someone to a life sentence for third-degree murder. My question is, has this been legally challenged in the Maryland Court of Appeals or the Maryland State Supreme Court? And is there any case law that we as participants in this deliberating body can refer to dig deeper into this subject? Because this is extremely troubling to me. This description falls under a different level of murder that is restricted from these sentences, and they don't square up. I think it's imperative for us as a body to address this and rectify this, and I sincerely appreciate what you're doing. Thank you.
So there have been cases where the felony murder rule is at issue, and sort of that rationale, the foreseeability has been affirmed by the courts in Maryland. What we can do is at the end of our slide deck, which I believe is available to everyone, is there's a resource page, and we will upload those pertinent decisions to that resource page for anyone who's interested in digging into that.
Thank you.
Seeing no further questions, thank you all very much for your time here this morning. And now it will be the afternoon, and we'll have the state's attorneys who are here to present. And this will be, is he, okay. Mr. Gibson, Mr. Harvey, Mr. Schellenberger, and Ms. Surincian, whose name I don't always get right, but I don't see her. Okay, whoever would like to go first? Mr. Gibson, go ahead.
Good afternoon, everyone. My pleasure to be here. Rich Gibson, State's Attorney for Howard County, Maryland, President of the Maryland State's Attorneys Association. I'm here representing all 24 prosecutors and the Chief Prosecutor for the state to support felony murder in our laws. Dr. Pam Basu lived in Howard County. She was 34 years old. She was an award-winning chemist. She was a mother of a 22-month-old daughter named Serena. She was driving her daughter to daycare on her way to work when two individuals, 16 and 26, decided they were going to carjack her. When her car was stopped at an intersection, they approached Dr. Basu, grabbed her, pulled her out of her vehicle, wrenched her from her car. As she was trying to get her baby out of the car seat, the two perpetrators sped off. She was entangled in the seatbelt and she was dragged approximately 2 miles. She died. The 16-year-old took the baby in the car seat and threw it out of the moving car as they sped away to escape. Neither defendant intended to kill anyone. They did not have the intent to kill anyone. They had the intent to carjack Ms. Basu. murder charges, any charges, criminal charges, break down into two elements: mens rea and actus reus. Mens rea is the criminal mindset, actus rea is the criminal act. What felony murder does is it allows one to transfer the underlying intent to commit an inherently dangerous crime to the resulting death and the desire to kill. It is important to note that felony murder does not apply to all felonies, only felonies that come with an inherently enhanced risk of physical harm to victims. For example, if I use my computer to hack into one of your bank accounts and drained all the money therein, and you hopped on your computer and checked your account and had a heart attack when you saw that all the money you'd worked so hard for was taken away from you, felony murder would not apply. Conversely, if I set fire to your home, if I kidnapped you, if I committed a carjacking or tried to commit a rape or robbery, an inherently dangerous crime where physical interaction is likely to occur, and someone dies, my intent to commit the underlying violent felony is transferred to the death. The intent to commit the underlying felony is transferred to the death. Felony murder laws provide justice to victims' families. They provide fairness because they create a potential outcome that captures the harm committed by the choice of the criminal act. Felony murder laws recognize that when criminals act in group, they tend to enable and assist each other. And if they played a role in committing a crime where death resulted, they must face the appropriate consequences. They're a critical tool for ensuring public safety, deterring dangerous crimes, and delivering justice to victims and their families. And with that, I will turn my time over to my colleague, Scott Schellenberg.
Good afternoon. So good to see you all. I'm sure you feel the same about seeing me, right? So a little bit of history. Felony murder comes from the common law. It has existed in the state of Maryland since 1635. Yes, you heard me right, 1635. 48 states, the District of Columbia, and the federal government all accept some format of felony murder. And it's been around that long. You all have codified the felonies that can constitute felony murder, which is really first-degree murder. Felony murder is the theory under which the state has gone. So we charge first-degree murder, and then when we get to trial, we can either try and prove first-degree premeditated, that you had thought about it and had the time to reflect, or that it was done during the commission of a felony. Delegate Bartlett. So attempts, it's not the attempt of the murder, it's the attempt of the underlying felony. So I go into a convenience store, I have a gun, I intend to rob, I pull out the gun, I say, give me your money. The victim pulls out a gun and the defendant shoots him and leaves without any money. Felony murder would qualify because there was an attempt to commit a robbery that wasn't completed, but I would have to show the linkage between the death and the robbery. I don't want to hear about money. $60,000 for every year somebody's in the DOC, someone is dead. Someone is dead, and $60,000 doesn't matter. It should not come into account. Remember, with regard to juveniles, you all have outlawed, and the state of Maryland has outlawed, life without parole for juveniles. So we're talking about life. So let me tell you quickly about one case. In 2018, during the time period that they got stats from, remember they said 17 to 19. Perfect example, 2018, Amy Caprio is in Perry Hall. Dante Harris is behind a Jeep that's stolen. 3 of his co-defendants are in a house burglarizing it. They've been doing this all day long. When Officer Caprio comes up to the Jeep, she confronts him. She pulls out her gun to get him out of the car. He nails the gas pedal, and he runs her over and kills her. Now, all of them were convicted of felony murder. And you're going to look at me and say, well, Scott, 3 of them weren't even there. but for the burglaries, they would not have needed a getaway driver, but for participating in the crimes. And the place where you draw the distinction is not in the crime, but in the sentence. Dante Harris, the person behind the wheel, got life. The other 3 offenders who were convicted of felony murder, you make the adjustment on the sentence, they each got 30 years. It's been around for centuries. It's in almost every state. We need to keep it here and continue with the way we do things. Thank you.
Well, you see, I don't get up here very often, so I don't know how to turn on the mic. You haven't heard from me in a little while. I don't get up here as often as Scott Schellenberger. I'm Bob Harvey. I'm the state's attorney from Calvert County, the jurisdiction who has the lowest crime rate in the state of Maryland. I want to talk to you a little bit about accountability. You know, when things go bad, it's pretty easy to blame someone else for your troubles. The other guy did it, not me. I didn't know that was going to happen. It's not my fault. I've even heard some people blame their legal troubles on the corrupt media. Some call this the blame game, and we see it all the time in the criminal justice system, every single day. As a prosecutor, I ascribe to a different philosophy. It's called personal accountability. An individual is responsible for his or her actions, for his or her decisions, for his or her choices. The felony murder rule is about personal accountability, holding an individual fully responsible for the consequences of his or her actions, decisions, and choices. Don't get me wrong, felony murder cases almost always involve the use of a handgun. 2 or more individuals get together, decide to commit a carjacking or to rob a convenience store, and one of them brings a gun to the event. During the course of the carjacking or robbery or the attempted carjacking or robbery, an innocent victim gets shot and killed. Bringing a gun to a robbery or a carjacking is an inherently dangerous activity. This is the kind of activity felony murder is designed to deter. The rule says, don't get involved in an armed carjacking or robbery because if something goes bad, you are going to be held accountable for it. And in terms of criminal culpability, where do you draw the line? Is the person who provides the gun any less culpable than the shooter? Is the person who plans an armed carjacking any less culpable? I personally don't think so. I personally think that everyone who knowingly participates in such an inherently dangerous activity is equally responsible for the natural and probable consequences that flow from it. Natural and probable you bring a gun to a robbery, what do you think is going to happen? If you don't want to use the gun, don't bring it. If you bring it, there's a pretty good chance somebody's going to get hurt. But look, if you don't agree with me about this, and I understand there's plenty of room for disagreement, consider this. Isn't the question of the level or degree of criminal culpability one for a judge or jury to decide? We charge it, okay, we charge it because that's what the law says, but that doesn't mean that a judge or jury is going to convict everybody we charge with felony murder. A judge or jury may look at that and say, well, number one, you haven't proven it, or number two, we don't think the level of culpability justifies a conviction for felony murder. We're going to find you guilty of the underlying robbery instead. It's a question for a judge. Why are we so afraid of a judge or jury deciding these questions? That's what a trial is all about. That's what a trial is for. So following the tragic death of George Floyd, there was a public outcry demanding that the police officers involved be held accountable for his death. Prosecutors in Minnesota, this may be surprising, prosecutors in Minnesota used the Minnesota version of the felony murder law to convict Officer Derek Chauvin of the murder of George Floyd. Section 609.19 of the Minnesota Penal Code, second-degree unintentional murder causing the death of another person without intent to effect death while committing or attempting to commit a felony. That's what that officer was convicted of. If you apply the theory that the public defender wants you to apply, where you have to have a specific intent to kill, Derek Chauvin likely would not have been convicted of killing George Floyd because he didn't intend to kill George Floyd. But he did intend to cause serious bodily harm to him, the underlying felony that they used to convict him. So by holding people accountable, such as Derek Chauvin, the felony murder rule plays an important role in our criminal justice system. As has been mentioned before, 48 states, the District of Columbia, and the federal government have it on the books. Maryland should not abandon or weaken the felony murder rule. Thank you.
All right, we'll take questions from the committee. We're going to start with the vice chair and then go to delegates Taylor and Arakan and Phillips.
Thank you, Mr. Chair. So I thank you, Mr. State's Attorney. I was going to direct to Scott Schellenberger. Thank you for helping me with the attempt question. So you mentioned that felony murder rule has been around for centuries. Right, since the 1600s. So why don't we have data to show in the state of Maryland when we utilize when someone is convicted under the felony murder rule, so that we can have something to show how many times it happens? And if you have data, please let me know.
We do not, and here's why. Under Section 2-201 of the criminal law in the state of Maryland, it's called first-degree murder. And there are ways to prove first-degree murder. So felony murder is not the crime, it's the theory. And therefore, as I believe the public defender has stated, we can't dig that out, because if we go to the DOC and say, well, wait a minute, you got 486 people down here in the DOC, all convicted of first-degree murders, which one were felony murder and which one were premeditated, you can't parse that out, because in the DOC it just says convicted of first-degree murder. And so that's why that is, I don't want to say impossible, but very difficult to parse out and figure out which is which.
But do you have an indication of how many cases that you have utilized this theory?
We utilize it quite a bit. And it's because that's what the person is doing. They are doing a robbery and they kill someone. They are doing the list here, a carjacking, a kidnapping, a rape. You know, it's the crimes they are doing that we latch onto and say, okay, it's felony murder. And you know, you have to understand, well, I think premeditated murder is something that's easy to understand. When you get up and argue before a jury, you know, ladies and gentlemen of the jury, it's premeditated murder. It's not a minute, it's not an hour, it's not a week, it's not even a second. It's that time it takes for a person to reflect upon what they are doing and to then do it. Sometimes jurors have a little bit of trouble with that. But when you can say, you know, he killed somebody while he was robbing them, that's felony murder under the state of Maryland. You heard the judge's jury instructions, and he told you if you're convicted of committing the felony and someone dies in the course of, remember, there has to be a connection between the dangerous, and that's what you all say, there has to be a connection between the dangerous felony and the actual death itself. So as Mr. Gibson pointed out, if he does something at home on his computer that causes someone to kill themselves or that causes someone to die, that's not felony murder, because you have limited it to
Is sodomy,
certain.
so sodomy's on the list. Is sodomy still a crime in the state of Maryland?
Technically, yes. Maryland is still a common law state, so all the laws that existed prior to them being codified still do exist. It's just it's easier to use the statutes that you all created, because then people can look exactly at the statute and know. And I'll defer to Mr. Gibson to help.
Just in terms of the sodomy laws, I think what is envisioned is a non-consensual sodomy event versus something else, just to be clear. So someone was forcibly sodomized, or someone would be forcibly raped, and then death resulted during the course of that action, felony murder might apply in that context.
Okay.
And actually, if you look at the statute, sodomy as that crime existed before October 1st of 2020. So it goes back meaning to
Okay.
what.
Okay, I get you. Okay, so that's just, I just don't have that little footnote there. One last question. Could each of you please provide me with, or provide the committee with the number of times within year 2024, I'm not even going to do ever, I'm just going to say 2024, where you all have used felony murder as a concept in your jury instructions to the jury?
Yes.
Calvert County, 0. We only
Well,
had
that's
2.
because you have the lowest crime.
We only had 2, we only had 2 homicides, none of them were felony murders.
Okay, thank you.
Delegate Taylor, then Eric Hand.
I didn't know they'd finished answering your questions. Thank you, Mr. Chair. This question is for Mr. Gibson. In your carjacking example, if there was no felony murder in our statute, if we'd gotten rid of it, how would those folks would be charged? Do we have charges that are applicable?
You would charge them with the carjacking,
Okay.
right? Because they did complete that act, right? As they were charged with the carjacking. But there would be no accountability for the loss of Dr. Basu. Like that, there would be no reckoning, no consequence associated with the death of Dr. Basu, because they never intended to kill Dr. Basu. They intended to take a car by force, right? And so you could prosecute a carjacking, but not the death. And so that family would remain, there would be no justice for them.
So, I'm sorry, may I?
Please.
So the driver of the car who drove 2 miles with a woman hanging out the door, there's no way to charge that person with murder if there was no felony murder on our books?
You could not charge that person with murder because one of the elements of murder
Is intent.
is the intent to take the life of another.
I hear you. So are there any other charges that would apply?
You could possibly charge, and to answer the other question, kind of to put 2 together, we don't have like a 3rd-degree murder. You could charge manslaughter possibly for the voluntary action that resulted in death, but the penalty for that is low. It's 10 years. It doesn't really reflect, taking a woman who's just trying to go to work and drop her kid off at daycare and dragging her 2 miles to her death and then throwing a baby out the window as you're trying to get away because you want to steal a car.
Well,
So
then,
like the gravity of the
would that not have
crime
been a
is,
separate charge? I'm sorry to interrupt.
no, I'm
The
sorry.
throwing the baby out of the window, would that have been some other charge, potentially? It resulted in murder?
the baby didn't die, thankfully.
Oh,
In that
okay.
setting, the car seat did its job, and luckily
Sure.
that the horror that family endured wasn't as grave as it could have been, right?
Yeah.
But you could possibly charge an attempted murder or forced degree assault. I have to look at the facts fully as to the tossing the baby out. It certainly was like a depraved act of indifference, right? But as to the murder of Dr. Basu,
Right.
you would not be able to create an outcome that reflected that harm.
And would the carjacking sentencing be on top of,
So
aren't they stacked sentences?
So the judges have the option of running time consecutive or concurrent. So a judge can say, I'm going to run each of these one after the other, creating a lengthier sentence.
Yeah.
Or a judge can say, I'm going to run them simultaneously, concurrently, to create a shorter sentence. And that really is in the discretion of the judge.
Thank you.
Delegate Eric Hand.
Thank you, Mr. Chair. Thank you guys for being here. You had mentioned that the other boys had gotten 30 years in the Amy Cabrio case. Can you just tell me how much time are they likely to actually serve? Can they get dim credits? Like when would parole kick in?
Well, several years ago, I believe, you all said that a person has to, if they're convicted of some type of murder, first-degree murder, has to serve at least 15. And I know at some point we were talking about 20, and I'm not remembering if that happened.
Okay.
But they would be eligible for DIM credits.
Okay.
They would be eligible for DIM credits based upon good conduct, based upon getting a job, based upon all the things that are allowed. And they will be eligible for parole. So they will not serve the full 30. It is highly, highly unlikely that they will serve the 30 years. They will serve some portion of that.
Okay, and what about the State's Attorney Gibson? Yeah, said 10 years for throwing the baby if they had been convicted, let's say, of throwing the baby without the felony murder availability. They get 10 years. How much time are would those guys actually serve if they were convicted?
To the point that State's Attorney Schellenberger just made, it is a great frustration of every prosecutor in trying to explain to victims what the actual outcomes are going to be.
Yeah.
Because it's really, I don't mean to be, there's no other way to say it. There is no like truth in sentencing.
Yeah.
So there's no like actual number. There's so many variables that go into factors that reduce a sentence. So let's say the person got the maximum 10 years. It could be as little as 4 or 5, depending upon a whole bunch of other variables that are too complex to.
Yeah. So if we had gotten rid of felony murder, then the people that killed this baby's mother could potentially only really be convicted of harming the baby, chucking the baby out the window. So they would have murdered the mother in a horrifically gruesome manner and potentially be looking at 4 years in jail.
Yes.
Terrifying. Thank you.
Delegate Bartlett, you asked a question. I want to make sure I try to get an answer as quickly as possible. There were 3 cases. There was a plea and 2 trials. You have Mr. Buckner, who we had a drug rip, a drug deal was set up, and then during the drug deal, it went sideways and someone was killed. And we had another case, which was a trial. Defendant set up through a buying app, set up an opportunity to purchase, I believe it was an iPhone, and the victim came to buy the iPhone, and then the defendant shot the victim. Again, you can't, we could prove that there was an intent to take the iPhone, which was stolen, but as to why the person was murdered, it was the theory that we proceeded on was felony murder. And the last one was another drug exchange that went sideways. Yes.
I'll get you my answers.
Delegate Phillips and Crutchfield and Carden and Williams and Collins.
So thank you, gentlemen. What I think we're talking about are some potential modifications to felony murder. What I've heard you describe are kind of really serious situations with very heinous crimes associated with really bad outcomes. I am going to ask my state's attorney, Mr. Schellenberger, in the Caprio case, the 3 individuals that were in the home, they were all convicted of felony murder.
Correct.
Okay.
But the adjustment was made in the sentence.
But the adjustment was made in the sentence. And I'm trying to figure out, wouldn't there have been other opportunities, and we had to think through how we might have charged them differently if they had no idea what was going to take place outside, even though something very bad happened. And don't answer that yet, because I got another question. I want to do a little.
That means I have to remember.
I want to do a little bit of.
Lots of compound questions there.
Yeah.
Get it out.
Well, I'll stop. Go ahead.
One at a time.
So, yes, they were burglarizing houses. They could have been convicted of, at least if they got caught burglarizing that house at the moment, which obviously limits it to 20 years. Yeah, first-degree burglary. They had been burglarizing other houses, but we were concentrating on the main case. So theoretically, if we could have proven the other places, then you could get those burglaries, yes. But again, the accountability for me is about everything. And that is, it's still about a but for. And that is, but for doing the burglaries, they would not have needed a driver. And but for the driver being confronted by an officer, the driver would not have had to run her over. And so we have to prove these nexuses, nexi, or whatever the word is. You have to prove a nexus between the commission of the crime and what actually, what crimes they're committing and what they happen. And you all have it limited to is committed in the perpetration or attempted to perpetrate the following crimes, and then you give the list: burglary, carjacking, kidnapping, mayhem, rape, robbery. We're limited to those inherently dangerous felonies where, because you're committing a dangerous felony, someone could die. And that's what you're being held accountable for when the person dies.
So let me do a hypothetical. My 18-year-old self, I'm hanging out with my boys, and we go to a party. And unintended, unknowledge, without knowing, one of those individuals that I'm with is just a bad guy and commits a rape, jumps back in my car, and we leave. Could you, not would you, could you charge me with felony murder?
No.
And why not?
Because the other person had not participated in the felony. And so the difference is, in the carjacking or the murder of Amy Caprio, he was participating in the robberies or the burglaries. But for them breaking into houses, they wouldn't have needed a getaway driver. But in your scenario, the driver has no idea about the rape, and therefore he was not participating in the felony. And so they would not be responsible. And I would go so far as to say, even if they drove away and got 3 miles away and your former self said, oh, you should have seen what I did when you weren't there, and tells them about the rape, there still wouldn't be responsibility. It would just be knowledge. He would be a witness. But there wouldn't be, I could not charge a felony or an accomplice.
All right. And Mr. Harvey, I just want to make one little bit of a fact check. You used the Chauvin case as an example with felony murder, and that was a little bit of a stretch because he was not charged with felony murder. There's a specific statute in Minnesota that they used, but it was not felony murder. I just want to make sure we're all clear on that. And he was charged with three different things: second-degree unintentional, third-degree murder, and second-degree manslaughter. And the other piece to all of that is all of those other people were there with him. Right. They witnessed it. They didn't act. Some of them acted, I think, negligently, but they weren't charged with any type of felony murder or with any type of murder.
Delegate, I read the statute, 609.19, murder in the second degree unintentional. I looked at it, and it says a person is guilty of that offense if they cause the death of another person without intent to effect death while committing or attempting to commit a felony.
But that's the first person, and they have a felony murder statute. That's my understanding.
Okay. Well, I do agree with you about he was convicted of 2 other charges. Thank you.
I'll stop.
Thank you, Mr. Chair. While I was sitting here, I noticed quite a few buzzwords were used in order to bring about your point of wanting to retain felony murder. You mentioned things like deterrence, public safety, accountability as reasons to maintain felony murder. But I guess my real question here with you is, what do you think about accountability? Do you believe that it's better to hold the actual perpetrator accountable versus all those parties, or do you really believe that everybody involved should be in some way have some kind of criminal action brought against them? So that's really my question. You know, I'm interested in knowing and understanding, you know, how you get here, because I have a hard time with this. I do believe strongly that the person that committed the actual act should be the person who should be receiving any criminal penalty whatsoever regarding that act.
Delegate Crutchfield, thank you for the question. The analogy that I would use would be sports, right? So when a Super Bowl team wins the Super Bowl and they hand out the Super Bowl rings, right? The player who sat on the bench for the entire game gets a ring. The coach who didn't play at all but helped create the opportunities for the players on the team gets a ring. The guy who drove the bus, who drove the team from point A to point B so they could play, gets a ring. Everyone, if you're involved at all, you're involved in all, right? The victory that occurred that day occurred as a result of everyone's involvement in creating that space for victory to occur. Crime in Maryland is very similar, right? If you are involved at all in helping to commit a horrible act, if you're looking at felony murder, right, then you are part and parcel of how those events occurred. We want to deter people from working together to commit crime. We want to deter people from committing crimes. And if you assist in someone's death because you intend to rob collectively, or you intend to rape collectively, or you intend to light someone's house on fire, and you have someone who helps you get the gas, someone helps you drive, then we're all collaborating together to light someone's house on fire, right? And death, when we're lighting a house on fire at 2 in the morning, and death results, the person who drove them there and helped them get there, the person who acquired the gas for them when they wouldn't otherwise had it, they all are party to that result. And even if they say, oh, I only meant to burn the house down, I didn't mean to kill anyone in the house. It's logical that if you light a house on fire at 2 in the morning when people are asleep inside of it, people might die. And if death does result, you can't say, we're not allowing you to say, oh, I didn't mean to, or oh, I didn't know. It's logical that this could occur, and you did it anyway. You showed great indifference to the sufferings of other human beings. And there should be a consequence that meets the horror that you've inflicted on those families. And that's why we believe felony murder should be retained.
And the adjustment is made in the sentence. You make the adjustment in the sentence. This is what they did. But because your role was different than the actual killer, as you've pointed out, I will adjust your sentence down and differently. So you have plenty of discretion as a judge, as a state's attorney. The Caprio case that I told you about, we offered the plea to those 3 people who were in the house burglarizing. That wasn't a trial. They pled guilty because we were saying, we'll let you plead guilty to felony murder and we'll recommend life, suspend all but 30. And believe me, those lawyers jumped on it. And that's how that happened.
One other point, too. The judge can suspend the judge can say life, suspend all but time served. That's within the judge's power. Not saying they would do that, but they could do that, right? And so there is a great deal of discretion that we give to the bench in determining what the appropriate outcome is per the person's level of participation.
Okay, but how often is that actually used? And then also, in your particular case in Baltimore County, we were dealing with juveniles. So there is a big difference. So that's my other concern. Even though, yes, we may give judges discretion, how often is that used? We don't even have data to indicate that. And that's a big concern as well. So what are we actually doing here?
Well, I think as we've heard is State's Attorney Harvey has had no cases. State's Attorney Gibson had 3. And I promise you I will get my research done to tell you how many I had and send you an email along with Delegate Bartlett and let you know. I can tell you that it happens often in jurisdictions like mine and Ivan Bates and some others, because people are bringing weapons to commit these other crimes, and then someone turns out to have died.
And then the other piece to that is the strategy that is used oftentimes in plea bargaining. So, I mean, I know there's no data around that either, but I do know that people are definitely charged at some point. But, you know, the charges, again, we talked a little bit about that earlier.
But if you were going to base your ideas and concepts on a plea bargain, then you might, you know, offer second-degree murder, because then the defense lawyer knows that the statute is, the sentence is capped. So it really has a lot to do with that. So what we're saying here is call the crime what it is and make the adjustments in the sentencing, which they did in the Caprio case.
I would also add, in terms of the charging decisions that are made, because you're referencing plea bargaining, you can't charge a case unless there is at least probable cause to bring those charges. There have to be facts and circumstances that give rise to the belief that this perpetrator committed this act, and that act was criminal. Secondly, for all the cases we're describing, for the violent offenses we're talking about, those matters go before a grand jury. So 23 members of every community hear these facts, and they have the ability to say no. They can know. So there's different levels of screening, if you will, or filtration, if you will, right? Because again, the grand jury has the ability to no-bill a charge. If the prosecutor said felony murder, but didn't provide adequate basis for felony murder to be the belief of the 23 grand jurors, then that charge would just fall off right there at that level. And for these kind of offenses, all of us use the grand jury. We're not proceeding via information for something like a robbery or a rape or a murder. And so the process is in place to ensure that the community agrees with the charges being brought against the perpetrators. And then, you know, because there's evidence to show that someone did it, there might be weaknesses in the case, there might be other issues in play. So plea bargaining isn't like a nefarious thing. It's a matter of how strong is my case? Are there weaknesses I have to acknowledge in the case? And is there an outcome we're trying to achieve in a way that's cost effective and emotionally not challenging to victims? It's going to take all these things into account.
Thank you, and please provide the information on all the other counties as well, if you could. We would greatly appreciate it.
Try.
Thank you.
Delegate Cardin.
Guys, for your testimony, and I find it very logical, and I appreciate that. And I also, you answered almost everything, so in advance, that's great. I thought that Delegate Phillips was going to ask, and so I'm going to follow up on something that he asked. Inconsistent sentencing. You've mentioned, Mr. Schellenberger, a number of times that you deal with this in the sentencing aspect of it. If there is inconsistent sentencing around the state, is that fair if it's similar situations? And I could just see the three jurisdictions here probably are very different in how prosecutors would recommend and maybe how judges would handle sentencing on those. So how do we deal with that? That would be number one. And I have one more question, which is a quickie. It's more process.
Well, as the representative of the state's attorneys on the Maryland Sentencing Commission, I can tell you that we have sentencing guidelines across the state which are intended and designed to reduce those kinds of disparities. Now, obviously, the sentencing guidelines are recommendations. They're not mandatory, but they do set forth a range of sentences across the state for a particular crime, a particular defendant. And I had a chance to look at last year's report, and I see that in 82% of the cases, judges in this state stay within the guidelines. So the disparities, to at least a large extent, I would like to think are limited.
The other thing that I think is important is each state's attorney is elected by the citizens of their jurisdiction. And therefore, I like to think that I am reflecting what they want in Baltimore County. And therefore, not that I want to volunteer this, but if anybody doesn't agree with me, then they have a way to express that. And so that's what my job is to make sure we are representing the citizens in Baltimore County. And you may say, well, then it differs from one jurisdiction to the next. Yeah, because each jurisdiction has different populations.
Okay. And just a quick follow-up to Mr. Gibson. Thank you again for your testimony. And it's great to see you again here. So in your fact pattern of that horrible carjacking that you described, couldn't you or didn't you or wouldn't you charge with, I guess it's what, armed or first-degree carjacking, first-degree assault, vehicular manslaughter, and I would think that you could probably charge second-degree murder, because even if they didn't intend to originally, they didn't have a forethought of killing anybody, if you're dragging somebody for, I would say even 100 yards, you realize at that point, I better stop or my intent has changed.
So I agree that in a criminal event, there are a series of underlying criminal events that occur within one event. So an easy example that I could use would be like, if you were to steal my car, right? You had to break the window. So you committed malicious destruction of property. You entered my vehicle and you didn't have permission to be in it. You committed what's called rogue and vagabond. You drove my car without my permission. You committed unauthorized use of a motor vehicle. When you stole my car away from me, you committed vehicle theft. If I had my computer in the car or a suit in the car, you committed theft of the items that were in the car as well. So in the commission of one criminal event, you could have a series of other criminal events. Now, as to your example in terms of Dr. Basu, the reason why second-degree murder wouldn't apply is because, again, two elements, the mens rea element still would not have been there. They didn't drag Dr. Basu with the intent of killing her or harming her. They were simply trying to effectuate their getaway with her vehicle, and she died. You would not have, I don't believe you would have been able to bring forth second-degree murder charges in that instance. You can bring forth carjacking charges, yes, as I stated earlier to Delegate Taylor, but you would not be able to, the murder, and you could probably bring involuntary manslaughter, or I'm sorry, voluntary manslaughter. Voluntary manslaughter, because death resulted through your actions, though unintended. But again, the cap there is 10.
Right, but if then you recommend to the judge who has the authority to do these consecutive, you're talking about well over 50 years if you get a consecutive sentence on all those different.
Sure, or.
That doesn't, not including second-degree murder.
If the judge was so inclined, and this is judicial discretion, the judge was so inclined as to run them consecutively, you could get something in the ballpark of 50 years. But to the Basu family who had their loved one dragged 2 miles, does that seem right? I would say no, vigorously, with all of my chest, all right? That family had a horrific event occur to them, and they deserve an outcome that reflects that harm.
And then just to follow up, it seems to me that the argument can be made, and maybe I've never been a prosecutor, so been a defense lawyer all my life, but it seems to me that the argument should be made that when you are dragging somebody, there is a degree of intent there after a certain amount of time, regardless of what the original intent was.
So when they're fleeing away from they took her car at high speed. She was dragged, I don't have this, she wasn't like dragged slowly. They're trying to get away. This whole thing, this whole event occurs probably within seconds, right? Like the whole thing from the grabbing her out of her vehicle, she's trying to get her baby out the back seat, the car's taking off as she's going. This is all seconds. So it's not,
right.
I agree that it's even more horrific if it was
2 miles at 50 miles, even if it's 50 miles an hour, that's less than 3 minutes, right?
Yes, so it's quick.
But after 10 seconds of dragging her, they say, we're going to kill this person if we're dragging this person at 50 miles an hour. You then know you have the intent to, you may not have the intent to kill her, but you have the knowledge that you're going to do it, and all of a sudden anyway, I'm sorry, Mr. Chair.
I'll just say that felony murder doesn't require you to parse that far. That is the strength of felony murder. The strength of felony murder is you intended to carjack and death result.
Which is why your argument is very logical, which is what I started with.
Thank you.
Delegate Williams, then Delegate Conaway, and then we're going to wrap it up.
Okay. Thank you, Mr. Chair. I just actually wanted to piggyback on the Vice Chair's request. State's Attorney Gibson, you mentioned you had 2 trials last year where you used felony murder. Were the conviction, did you get the conviction in both of those trials for the felony murder?
Yes, ma'am.
Okay. If you guys could provide not just the times in which you charged, but also the convictions for the felony murder charges for the jurisdictions across the state, that would be great, as well as, and I guess my second question is also too, you know, you mentioned 80-some-odd% of the time the judges are within the guidelines. My question is, are there any times in which the convictions have exceeded those guidelines in a felony murder case?
So judges, as
I'm sure they have.
yeah, as
A judge, 82% of the time, judges have remained with guidelines. That's for all crimes. All crimes. Judges can obviously depart from the guidelines. They can go above or they could go below.
Right.
The caveat to that is they have to state a reason. They have to give a reason for it, and there are a set of reasons within the guidelines, and the judges can also find others. But at least in my experience, and I practiced throughout the state as a defense attorney before I became a prosecutor, judges by and large stay within the guidelines. You know, the exception, though, however, is very, very violent or serious crimes. They will go above. So I hope that answered.
Thank you.
Delegate Conaway.
Chairman, thank you, panel, very much for coming in. Previous panel gave us some information that said in a Minnesota study, they found that less than 1% of the individuals knew about the felony murder rule. Would you agree with that? Would any of you agree with that or comment on it?
No way of knowing, but I do agree
That's fine, that's fine.
I do agree that it's the parents' responsibility.
It's parents. Okay. No one said that. No one has said that. So you talked about personal accountability. So how are you holding people personally accountable for things that they don't know and weren't taught? But you know it. You know it, and you haven't taught this. I mean, for example, you talked about the sodomy, which we took off the books. But then someone said it might be still applicable on the books. When I'm looking here, there was a capital offense in Maryland in 1642. So now I'm confused. Is what we do null and void here, even though we put it in writing? What are you saying?
No, Delegate Conway, thank you for the question. I think that the crimes that are enumerated are the kind of activities that everyone knows are wrong.
I would totally disagree with you, because I just read to you that the people don't know. And some of the statements that you made up here, or the panel made, I don't know. And for example, something was talked about this, someone had a heart attack because money was missing out their bank account.
Yes.
Well, if you had money in Old Court Savings and Loan high risk account that you knew wasn't federally insured and you had more than 10,000, of course, your money might be missing. So vigorously,
that was not
vigorously, I'm going to say, who should be held accountable in this society for this deliberate act of ignorance and not teaching people? And I would refer you to Carter G. Woodson, not the miseducation of the Negro, but the general miseducation of black people.
So again, Delegate Conway, thank you for the question. The way I would look at it again is, I think that most people understand I should not commit a robbery. Most people understand I should not light a house on fire. Most people understand I should not rape or sodomize someone in obviously non-consensual interactions. Most people understand I should not carjack someone. That's a fundamental thing. I agree that, you know, how you're raised matters, but the average person should understand.
The average prudent man. Does the average prudent man understand no means no?
I would hope so.
Oh,
absolutely.
really?
I would hope so. I would hope so.
All right. I am going to go to Delegate Phillips, and then we definitely are done.
Information request, Mr. Chair.
Sure.
So in parsing out the information that you all are going to share with us, could you parse out also those individuals who you prosecuted who I'm going to call the secondary versus the primary, if that's possible.
We will try. That's going to be hard.
Because like, as
So,
an example,
in other
those
words,
three,
who was the car driver versus who was the other?
who was the shooter
Right.
versus who contributed, right? I'm just curious, if you could parse that out in any way, shape, or form, that would be helpful.
Okay.
It'll take a minute to get there.
Yeah, for sure.
Thank you all very much for speaking with us today. This is a complex issue, and Delegate Crutchfield and I have had sort of a running conversation about this issue now for several years, and what I think is fairly clear is it is a complex legal issue that we don't get to spend a whole lot of time on. And so I will say that I feel like the conversation and the questions that have come from the committee were very insightful and thoughtful. I'm not just saying that. This is a very hard thing to kind of parse, so I want to thank the committee and I want to thank the people who presented today for coming in. And not to make light of it, Delegate Conway, I also was able to check off on my bingo card a reference to Old Court's savings and loan. That's a 1980s callback, and I'm pretty excited that I got to check that off. With that, we are adjourned. We will be back on Tuesday with a long day of bill hearings. Thank you.
The Conway